Okay, welcome everyone to this webinar, which is being co-hosted by the Association of Governance, Risk and Compliance, ComplyPort, and LGCA, with AGRC and LGCA particularly here as sponsors. I am Matteo Harrincuvi from AGRC, and I'll be moderating this session. Before getting started on this very exciting and pressing topic, let me get some admin issues out of the way. First of all, we are recording this session, so there will be a video recording available for everyone a few hours after the event. We will be sharing that on YouTube, etc., and disseminating across social media channels and whatnot. But give us some time to get those out. Also, if you're listening to what Graham and Luis are going to be presenting and you have any questions, make sure to drop the questions in the chat. We will have about 15 minutes towards the end of the session to discuss some of these questions. We won't be able to answer all of your questions, but we will provide you with the contact details for both Luis and Graham, who can help you out with any sort of pending issues or other queries that you might have. So with that said, hope you have a great webinar. Let me first ask both Luis and Graham to briefly introduce themselves, and then I'm going to hand the reins over to Graham, who's going to lead the presentation and discussion and whatnot. So Graham, can you tell us a little bit about you and who you are, what you do, etc.?
Sure. Hi, my name is Graham Livy-Sampro. I'm a director at ComplyPort, responsible for one of the ongoing client services teams, basically delivering services to our retained and ad hoc clients throughout various different sectors, both retail, wholesale, and covering a wide scope of firm type as well. I've been with ComplyPort now 14 years, and I've been doing this particular sort of role consulting for well in excess of probably 15 years now, definitely. But there we are. We'll see where we end up. It should be an interesting session. Hopefully we'll get some questions, and if not, please do follow up. There'll be contact details on the slides, which I believe will circulate as well afterwards.
Thank you, Graham. Luis?
Great, thank you. Luis Parra. I've been with helping my clients over the last 15 years use technology to really kind of help solve some of their problems, make people a little bit more efficient at their jobs. We all have a lot more data, a lot more change in regulatory things that we need to monitor and handle, and can help our clients use technology to the best of their needs. We are looking forward here to presenting not only our regulatory business solutions, but also a little bit about how technology can help address those solutions. So thank you.
Thank you, gentlemen, for the introduction. With that said, I'm going to turn off my camera, mute myself, and basically it's all in Graham's hands. Hope you have a great session, and we'll see you in a bit for the Q&A session. Thanks.
Thanks, Matteo. Well, welcome everybody. As I say, this is going to cover a couple of items, most notably the Gateway Consultation Paper, and also Policy Statement 2210, which, as most people should know or be aware of, that it's fully come into force as of today. So what we'll do is without further ado, we'll kick off with basically you have a list of speakers there with our contact details, so we can gloss over that one. And you can come back to it at your leisure. The agenda for today, roughly, is to give you a bit of background, which most firms and most individuals are probably aware of already, how Section 21 currently stands, and then moving through, basically through the consultation paper of the FCA's proposals, the transitional regime, and also covering off PS 2210. And also then a final look at consumer duty, because as we've seen more recently, consumer duty is basically now cutting across every area of the handbook. And this is just another way for FCA to ensure that the consumer outcomes are at the focus of firms' minds. So we'll start off with an interesting little fact, 95%. Basically, this represents the percentage of interventions that the FCA has had with authorised firms in relation to financial promotions. This comes from their Q3 2022 data, where over 4,150 promotions were either amended or withdrawn, which is basically the highest since the FCA started publishing this type of data. And the areas that basically were focused on were retail lending, investments, and banking. that had the highest rate, basically, of amendments or withdrawals compared to the rest. So it makes for interesting reading, and it gives a sort of a set scene for where we can see the FCA going in the future. And I think, coupled with consumer duty, this is where ultimately we're going to find FCA sort of focusing its direction to make sure that firms are meeting the consumer duty in this particular regard. So background to this, essentially, consultation paper 2227 follows on from the HM Treasury consultation in July of 2020, where certain risks were identified in terms of firm expertise, lack of due diligence carried out by the approvers, and challenges for the FCA, basically, of having an oversight of these firms that were basically approving unauthorized firms' financial promotions without necessarily doing relevant checks. I'm not saying that was everyone, but that was a predominant feature that basically was identified. Consultation basically came up and proposed, certainly from HM Treasury, for a new regulatory gateway for financial promotions approvals for anyone that wants to approve financial promotions. And then that's been enshrined, or will be enshrined, in the Financial Services and Markets Bill, which is amending FSMA 2000. It's designed basically to give more effective prevention or intervention to ensure firms, and you'll see at the authorization stage or the approval stage for the gateway, that the FCA is going to make sure that those firms that are becoming approvers of financial promotions are have suitably qualified individuals, and they're actually providing approval for promotions that are within their scope of expertise. It also gives the FCA a chance to have more oversight and supervision of this particular area, and it's concerned for them, particularly in regard when we look back again at consumer duty, and we'll cover that off a little bit later on. Section 21 of FSMA currently, basically, as everyone should be aware, under the current rules, you can only communicate a financial promotion if you're authorized, or if it's been approved by an authorized firm, or an exemption applies. So basically, those are the current restrictions in place. So anyone at the moment, and until these consultation paper turns into policy statement and into final rules and is enacted, basically is the status quo. So it's basically the firm's responsibility to ensure compliance with the rules under COBS 4, especially making sure the information is clear, fair, and not misleading. And what we'll see with the consultation paper is it's designed now to take that one step further, or in fact several steps further, in terms of the actual scrutiny that is being given to these financial promotions that are being approved by firms for unauthorized firms. So FCA's proposals in 2227 are as they're listed there. Basically, if a firm wants to be able to approve a financial promotion, it needs to basically apply to the FCA, or it will need to apply to the FCA for permission to do so. Some exceptions apply there, obviously, where it's part of for an authorized business in its corporate group, whether it's for onward communication by an unauthorized firm, but it's the firm's own promotion, and where it's an appointed representative, where the firm has accepted responsibility for that, or appointed representative's business. It's important to note, though, with this, there are no deadlines as of yet. But once the rules come into effect, there will be a period where firms will need to apply if they want to approve promotions outside of the exceptions. Another thing to bear in mind is another statistic that comes out of this is that FCA has a target of a 50% reduction by 2025 in the number of consumers investing into high-risk investments who indicate a low risk tolerance. So approval is going to be challenging, to say the least. We've seen certainly in other applications a ramp up in scrutiny by FCA of the applications, certainly looking more at threshold conditions, at the experience, at the individuals involved, and how the firm satisfies those. So essentially, it's looking at higher standards of firms and those coming through the gateway, higher quality promotions, so that individuals are actually able to understand and actually the promotions are in plain English and that it's directed at the consumers that it's meant to be for, and also then linking back with the consumer duty that it's only received where the risks are fully understood. Some of the key content for the CP is listed below on this slide here. It basically contains a number of proposals, some of which are quite key in terms of looking at it in terms of the reporting requirements and the ongoing requirements the firms are going to have if they're an approver of financial promotions. And it also gives out details of the basis that the FCA will either grant or refuse applications. I mean, it's very broad criteria again, but it follows broadly in line with looking at the FCA's operational objectives as well as the threshold conditions. But bear in mind, all of this is subject to change because this is only consultation at the moment. It then moves into policy state once once the bill has transitioned through Parliament in terms of the amendments to FSMA 2000. But given recent interventions by FCA, and we've seen the marked increase in interventions and the concern the FCA has over the ability of consumers to understand both the financial promotion itself and also the risk involved in some of the investments, it's unlikely that the consultation paper will differ greatly from what has been set out. And also it follows on the back of and is addressing the queries and concerns raised by Treasury back in 2020. Transitional regime.
Graham, we do have one question
again,
I'd like to go ahead and interrupt you for and to ask here, which is, can you what is defined as a promotion? Since you're referencing promotions over and over again, I thought it'd be pertinent to interrupt you here with that one. Thank you.
Sure. A promotion is basically any inducement or any marketing material that talks about a product or services, inducing them to either otherwise engage with a firm that they might not ordinarily do. So it still has the sort of same standard definition. Hopefully that addresses the question. Okay, moving on. In terms of the transitional regime, again, final details will depend on the contents of the legislation when it's passed. But broadly, anyone that applies within the application period will be able to continue approving financial promotions until the FCA either approves or denies their application. FCA, again, as with normal authorizations, has up to 12 months to decide whether the application will be approved or not. But basically, if unsuccessful in applying, you'll have to stop any approval process or any approval activity immediately. It's important to note that also if you fail to apply during the initial period set by the FCA, you won't be able to approve financial promotions again until your application is determined. So if you don't apply to a window they set up, you'll have to stop approving financial promotions until you've submitted your application and the FCA has determined it. But as long as you apply during the opening period or the transitional period, then you can carry on approving. Although, just be cautious. I mean, we've seen this with the TPR applications, and we've seen it with other applications. It doesn't mean that you should just get an application in for the sake of getting an application in if you want to be an approver. It needs to be a robust, complete application, needs to meet, as you'll see, the threshold conditions, and also, not be a risk, as the FCA would see it, to their operational objectives, which is basically the protection of the consumer. So it's very much a circular process in terms of where the FCA is taking this. The approval process itself, basically, as we've said, it's assessment by reference to the operational objectives and the threshold conditions. But in addition to the criteria we've got there, in particular systems, controls, and processes in place to both ensure initial compliance and ongoing monitoring of financial promotions that are basically being approved by the firm, the application needs to detail the types or types of promotion the firm is seeking to approve. And if it's different from the firm's existing Part 4A permissions, or different instruments or different criteria, then basically the FCA is going to subject that application to additional scrutiny, because they'll want to make sure that the individuals within the firm are competent, capable, and able to assess the financial promotion in question before it goes out to consumers. In addition to those, and also, as FCA does with all applications, it will look at market research, any complaints data, and the supervisory history of the firm in question before determining an application. They can also, and this is at their own initiative, vary own initiative and discretion, I should say. They can vary the gateway permission that's applied for in order to be able to grant the approval. So you may apply for multiple investment types or multiple investment instruments that you want to be able to approve financial promotions for, but the FCA may come back and say, well, actually, no, we don't agree with this, and we will approve all these particular ones, but these other we will not. And that's at their discretion, but it's a way of sort of meeting firms, in a sense, halfway until firms can actually justify and meet the criteria of the FCA. Again, as with Part 4 applications, firms will have the usual route of referring basically after the FCA to the upper tribunal as a method of last resort, should the application be refused. Post-approval. Basically, there's a number of criteria. The two main things that firms need to be aware of is obviously within 7 days of every approval, withdrawal or amendment of a financial promotion. That following information listed there has to be reported to the FCA. Now, if you're doing a number of financial promotions a day, then that could become significantly burdensome. Now, as a reminder, this only applies to promotions that are not your own or not for your own business. So this is ones that you're approving for unauthorized firms. But for those firms that have have this as a mainstay in business, then it could be a considerably large amount of work to undertake. There is also then the biannual reporting, which basically needs to be submitted within 30 business days following either the firm's accounting reference date or the date falling 6 months after that accounting reference date, whichever is first after the transitional period ends. Although firms that are applying during the initial period will need to comply with these requirements basically from when the transitional period began. The consultation, again, as we said, I haven't actually said directly, but the consultation is due to end in 6 days' time on the 7th of February, with the final rules expected sometime in the first half of this year. But that also depends on the progress of the legislation through Parliament and whether, and the timing of royal assent and the time it's enacted. So it's very much a watch this space and wait and see on the sort of the consultation paper and when it will come into effect. But naturally, we will keep an eye on this and keep an eye on the progress. We have been keeping an eye on the progress of the various different bills that are going through Parliament at the moment. We couldn't really do today without having a look at Policy Statement 2210. Now, it was a significantly detailed piece of rulemaking, really, in terms of FCA. And as everyone probably is aware that sat here, all of the rules now, as of today, are fully in force. So you'll see in the handbook's changed. You've now got new sections for RMMI, NMMI, and so on and so forth. So the rules now obviously distinguish between readily realizable securities, which have no marketing restrictions, and all the way up to NMMI, which have the most marketing restrictions. And it basically, NMMI covers funds and similar vehicles of that particular nature, and have the highest level of restrictions before you're able to market to the client. just to cover off, RMIs aren't available through direct offer financial promotions, but they can be accessed by certain individuals or certain investors, depending on their categorization, high net worth individuals and sophisticated investors. But there needs to be a personalized risk warning, a 24-hour calling off period, investor assessment and declaration, and appropriateness testing to go with that. So there is a whole body of evidence that needs to be basically submitted, or not submitted, but needs to be on file in order for any activity to be carried out with those particular, well, for those investment types with those clients. For MMIs, it's very much only to retail clients that are certified as high net worth individuals or self-certified sophisticated investors. The personalized risk warning, a 24-hour calling off period, an assessment again, and declaration forms. And in addition, there has to be a suitability assessment, which goes further, as we'll see, than the appropriateness test does. So some of the key elements that now need to be in place, basically, standard and personal risk warnings have to be personalized for each investment and client. This already came into effect actually back in the beginning of December last year. But basically, all risk warnings now have to be prominent, have to be legible within its own border, and have relevant text, basically bold or underlined, and also have to be consistently visible. There can't be any feature of either a website or similar that would occlude it or make it less visible. Risk warnings, incidentally, on websites have to be visible and statically fixed at the top of the screen and need to be present even when scrolling, and should, the FCA says, be below anything else that is statically fixed. So there's some challenge for the web designers. Well, I'm sure it's not a challenge for most. We've seen it with the CFD industry in recent years, and it's just now FCA is extending it further. Specified risk summary templates are available in COBS 4 Annex 1, and that's basically, it varies depending on the product, but FCA said it should take around 2 minutes to read. Now, bearing in mind you have to think of 2 minutes, that's a reasonable amount of time, but not everyone reads at the same speed. So take that into consideration. Again, that then back to consumer duty and whether people are able to understand and how easily and readily able they are to understand that information that's available to them or that's presented to them. 24-hour cooling off period. This is for first-time investors with a firm. But again, as we'll see with consumer duty, there is a suggestion that firms may want to consider making this longer, depending on your assessment of the client's or customer's vulnerability and their ability to understand the risks involved. And again, it's linking back, as we said, to looking at consumer duty in that particular regard. Looking at client categorization in terms of the evidence component, basically it's getting slightly more granular in that it's looking for individuals to state their income to the nearest 10,000 or 100,000 for high net worth individuals, or if they're coming across for self-certified sophisticated investors, then they'll need to basically declare which company they're a director of. Checks by the firm, the FCA have said, will need to include that the income and net asset amount is over the threshold, and that the company exists, but you won't necessarily need to require bank statements from your prospective clients, which I think you'd be hard pushed to get in any case. It's hard enough sometimes getting the relevant information in the first place. Appropriateness test. Does the client have, it is sort of, we've seen this in other high risk areas. Does the client have sufficient knowledge and experience to understand the risks involved? If they fail the appropriateness test, they are able to retake it. But after the second time they fail the test, there is a mandatory 24-hour period, a minimum 24-hour period before they're allowed to retake it. And firms are prohibited from either encouraging the client to retake it or informing the client of what questions were answered incorrectly. And then when we look at suitability for NMMIs, basically it goes further than the appropriateness test in that it requires the firm to ensure that the investor understands the risk involved, and also for the firm to understand the client's personal circumstances and to assess basically whether this investment meets their needs or objectives. Again, circling back, consumer duty, and we can see, you know, as a general theme, this is running through the entirety of the proposed legislative or proposed changes coming through. Record keeping, again, I mean, it's metrics based. FCA wants to basically see how effective these measures have been. So it's another regulatory burden on firms to basically keep these records, because FCA will come along and ask for them at some point in time, normally between 3 to 6 months after implementation. But we will see. That's not been discussed as of yet, as far as I'm aware. But it's going to look at things like number of users presented with the RMMI risk warning, number of those who then click on the take 2 minutes to learn more side, number of consumers who do not proceed, number subject to the 24-hour cooling off period, the outcome of client categorization and the reasons for each, among other criteria on that front. Talk about consumer duty. You know, FCA basically, duty is the biggest sort of piece in the FCA's remit at the moment. It covers not just, you know, it brings everything together under the one duty, and I hate using that the word again, but the responsibility of firms to the consumers, it's basically, you have to consider this during the process of approving the financial promotions. You need to ensure that basically the information needs of each customer is met, that it's likely to be understood, and is capable of allowing them to make effective decisions, basically. So any clients that are vulnerable, or you have different information, that things might need to be slightly amended for them, they have to be tailored, to the complexity and the vulnerability of each client. And the FCA is encouraging firms to basically monitor the effectiveness of the risk warnings and risk summary document as part of the monitoring obligation under the consumer duty. And again, as we've said, longer lockout than 24 hours may be required in order to deliver good outcomes for consumers under the consumer duty. But that broadly brings my part of the presentation to the end. So I will hand over on the next slide to Lewis.
That's quite a bit of information, Graham. Thank you for covering. There's obviously a lot of things to think about for firms as additional consultations need to happen. A lot to think about there. And so we have the technology to be able to assist with a lot of these tracking, a lot of the monitoring of the changes that happen. So if we think about how a company typically might do approvals, when you're first kind of starting out, you rely a lot on potentially on email. And that's probably not the best way to have an approval process take place. Really, when you have to think about 3 years down the line, am I going to be able to prove up or document that back to the FCA in some audit? We've had our clients come to us and say, well, the FCA just came in and asked for the last 3 years of our financial promotions. And, so what are they looking for there? They're looking for you to provide not only the financial promotion, but the process that it went through, who approved it, and declinations are just as important. Why was it declined? And what did that result in? Were there additional training opportunities that occurred? Was there a change to your policy? So with all the content that Graham has covered, there's an opportunity here for you to have that policy not just be an item that's written and is in the cabinet, but is being used as part of a process. So there's a workflow involved for requesting an approval. The approval process itself brings the requester into the process so that they know why you might decline something. Is it fair and balanced? which, who are we targeting? Has this promotion been run in the past, and what are the metrics behind it? These are some of the data points that the requester needs to think about when they're putting together the promotion, so that when the firm goes ahead and approves it or declines it, they pretty much it becomes a self-running type of process. And of course, the important part of that is to be able to then click on any period in time and be able to report on all of these things. So Comply Portal is just one of our tools. Comply Port, it's one of our technologies. There are other tools like this. There's just too much data out there to keep that in SharePoint and Google Forms and other pieces. You really need to have a more central way to track the workflow of the request and the approval process, along with the financial promotion. So that's my piece on that. So thank you, Graham, and I think Matteo, I think we're ready for some questions, perhaps.
Thanks,
Actually, I think it's back to Graham. You.
There's just some of the support that we can offer. I mean, it is listed there. We can help firms prepare reporting materials. We've got dedicated teams that will do that. We can assist basically with variations of permissions and support and guidance when communicating with the FCA. We've undertaken a number of quasi 166s where we've assisted firms to basically ensure and come out of issues where FCA has, let's say, prohibited them from making financial promotions until they make their amendments to them. And we've assisted firms doing that, so we're more than happy to assist in any area that we are asked to do so in terms of that. But yes, as you said, Q&A.
Excellent. Thank you, Graham. Thank you, Luis, for the presentation and for providing us with a wealth of information on financial promotions and what is in line by the FCA, etc. So we have 8 questions that have been rolling in. Some of them are a little lengthy and they have a lot of kind of explanatory notes. So I'm going to walk my way through these. I'm going to start from the top and work our way down. Some of them might be actually faster for you guys to respond to. But let me start with the first one that came in, which was 30 seconds within the start of the webinar. So they must really want an answer for this. But basically, the question says, the rules will allow an authorized firm to approve its own financial promotions. Would this extend to the PROD or PROD rules where a firm identifies itself as the manufacturer of the product? I am thinking here of products where there is a third-party element to the relationship. For example, the delegated authorized investment manager for an investment trust, signing off the marketing material for the investment trust, which is a separate third-party legal entity that is not itself FCA regulated, although the PLC is subject to listing rules, etc. Any thoughts on that, Graham, Luis?
Off the top of my head, I wouldn't want to answer that particular one right now. I think it's one that particularly in terms of the CP, we need to go back and have a look and see. I don't believe they've said anything in particular, but my guess is that or my best assessment of it would be that, given this is focusing on looking at unauthorized firms making financial promotions, or basically putting an approval process in place for that, that they would need to go through some form of approval somewhere along the line before going out.
Okay.
But I'm happy to have a further discussion certainly on that one. It's an interesting question to look into.
It's a good case study, I guess. We had the gentleman who asked about, to define promotion, and thanks, Luis, for stepping in and, posing that question, presenting that question at the time. He had a few follow-ups. He's asking about mortgage tips. Would that be okay? Basically, as long as I don't request for them to call me, etc.
If it's, I think you've got to think about it as if the FCA would see it as a financial promotion. Now, it's whether it's presented as such, and whether it's more than just marketing material, whether it's giving advice or similar, then yes, you could argue that it is potentially considered to be a financial promotion.
I think he just had a follow-up. He's mentioning like TikTok videos or Instagram reels, like short tips in that sense.
FCA has always been media neutral, so anything of that nature is still going to need to be looked at.
Okay, excellent. Next up, we currently are fully authorized for general insurance and consumer credit broking with 2 ARs, which are separate limited entities within the group. The principal firm approves all the financial promotions for the group. Are we subject to this approval process with the FCA?
For ARs, basically, if you're approving ARs that are in the same business, then that would meet one of the exemptions. But if not, then you would be subject to the approval process.
Okay. What do we have now? Question 5. We are not FCA regulated. We rely upon an FPO exemption, HNWSI, where we make a financial promotion. Do we need to comply with the FCA's requirements regarding HNWI's assessment?
Basically, they're in terms of policy statement 2210. Yes, you would need to follow those the new rules requirements basically.
Let's see, what else do we have here? Okay, we have, I think, 4 more questions. Let me see. If the recipient of the FP is taking their own advice, then can we avoid an appropriateness test? Advice from an FCA regulated advisor or accountant lawyer?
Short answer to that one, I don't believe so. But I think I'd like to double check that one. I think that the whole idea is that basically, the firm has to basically, the appropriateness test is designed to make sure that the firm has I think it's a reasonable understanding that the individual understands the risks involved and is suitably experienced. So again, I think that's probably something that needs to wait and see what the final policy statement and final rules actually indicate or point towards.
Right. Next up, I don't think this is a case study. This, I think, has more to do with the regulation, but let's see. What level of evidence are firms, such as crowdfunding firms with automated onboarding, supposed to get to back up information given on the categorization certificates, particularly in relation to the self-certified sophisticated certificate?
I think it was partially covered on the slide, on one of the slides, but the FCA haven't really given any detail of sort of the backup of evidence, but they are saying, you're not supposed to obtain bank statements. They even say, I think, not even to have to check Companies House for the directorship. So I mean, obviously that's not something that I would recommend. I would say, you obtain as much evidence as is reasonably possible to basically back up the categorization that you've given to that particular investor.
Okay. And the person had also a follow-up question to this, a similar point. When a member of a crowdfunding website has an existing certificate that is in the old version, does the firm need to get a new certificate before any further DOFP are made?
On that one, can I come back to that one? I will, if we can get an email address, I will look into that one and just double check before I double check, because that was a subject of some discussion earlier on this particular topic.
Excellent, Graham. We have 2 more here, and I think that brings us to an end. It's another case study, I guess. We are an FCA regulated firm for corporate finance business, a small cap broker and corporate finance firm acting in the listed space as a nominated broker, LSE member firm, where I presume we can still sign off on financial promotions without asking the FCA for this new permission. We only deal with FCA regulated investors, primarily who are professional, no retail clients. I presume I do not need to seek this new permission, right?
Basically, if you're approving financial promotions for unauthorized firms, you would need to apply for the permission. If you are signing off for yourselves or one of the exemptions, then no, you would not. But it is predominantly targeted, towards retail clients.
Right. Last but not least, one that just rolled in. As a directly authorized insurance broker, will I need to follow this new process for FPs?
It basically covers it covers all financial promotions. Yes, essentially.
And we have one last question that just rolled in, which is a clarification, really, in terms of the exemption listed above, approving their own financial promotions for onward communication by an unauthorized firm. Can you clarify that concept for them, Graham, please?
Yeah, sure. It's basically where a firm has its own financial promotion. It's approved it as it's as it's permitted to do so under the rules, and then it passes it on, let's say, to a third-party marketer that isn't an authorized firm.
Okay, that should clarify that issue. Any word on crypto firms?
Crypto firms, interesting. And I recognise the name with that one. It basically they are due to fall within RMMIs or potentially fall within RMMIs, but it's all subject to the legislation that's currently going through at the moment, and subject to further clarification. So that's where at the moment that's where that one sits.
Right. I guess everything will become clear once everything is kind of hammered out and we have a full a more final version of the regulation.
one would hope, yeah.
Yeah, one would hope. There you go. If there are no more questions, any other comments from you, Graham, or from Luis, before we wrap up? Because I think we've covered all of the questions. And also to everyone listening in, I know Compliper will be circulating the video recording, and they'll have contact information to both Luis and Graham. So if you want to follow up with any of these questions or want more information or consultation, etc., please feel free to get in touch with them. They'd be happy to help. But yeah, any final remarks, Graham, Luis?
No, nothing from me. Just thank you to everyone for attending and going through the presentation with us, and for the questions as well. Some challenging ones there.
Yeah, no, thank you very much. Some of our regulatory business consultants may be following up on email just to get your feedback, additional topics to cover, and to see if we can directly assist you with any of the topics covered here today. Okay, so look forward to hearing from you. Thank you.
Excellent. Before I say goodbye, just to get some final admin issues out of the way, we have recorded this session. It will be circulated shortly, and you have everyone's contact information. So thanks everyone for attending, and hope you learned plenty and have plenty of questions to raise with both Graham and Luis. So thanks, and until next time.
Thank you.
Thank you.
Bye, everyone.